The next matter before the court this morning is Discovery Resources Incorporated versus Ernst & Young LLP et al. We are running a little early, gentlemen. We're ready to take the case. I just want to make sure we're not waiting for anyone else to appear.
We're not waiting for a deal.
Thank you. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, if you let me know I'm keeping the clock this morning, I can keep you abreast of the passage of time and let you know when you're invading into that rebuttal time. We have read the briefs and we're ready to proceed when you are. And counsel, if you would utilize this podium up here.
Oh.
Thank you.
Good morning. May it please the court, my name is Timothy Shinko and I represent the appellant in this matter. And I would like to start.
Oh, I apologize, Judge Cannon. I should have done that earlier. I would like to let you know that we have Judge Cannon from the 11th sitting with us today, visiting, filling in for one of the 9th District judges. So I'm sorry that I didn't.
Good morning, my pleasure to meet you. I would like to begin the discussion this morning, and I would like to say 5 minutes.
Sure.
But I'd like to begin the discussion this morning with my fourth assignment of error, which is whether or not the court should have ordered the matter be stayed between Scherzer and DRI as a result, because there is no arbitration agreement between those two parties. And that is the first point I'd like to make, is that Scherzer and the appellant are not signatories to any agreement compelling arbitration. It is well settled that arbitration is a matter of consent and not coercion. The party may not be compelled under the FAA to submit to arbitration unless there is a contractual basis for doing so or concluding that the parties agreed to do so. Now, neither DRI nor SI can be compelled to arbitrate because there is no agreement between them that has any there's no agreement between them, let alone one that has one with an arbitration clause. And I would direct the court's attention to a Sixth Circuit case, Javits versus First Union Securities, but it is a Sixth Circuit case deciding New York law. And this Exhibit 1, whatever it is, states that it is to be interpreted under New York law. And I concede that point. The question is Exhibit 1 a contract or is it not a contract? That has to be determined under New York law. So the court in Javits was faced with a similar situation as to what we have here. A non-signatory to an arbitration agreement was attempting to enforce his rights to have arbitration with the signatory. And the court said, well, there are issues when a non-signatory may compel arbitration. That would be one where the issues are intertwined. But the analysis doesn't stop there. The courts then go on to say, well, yes, the issue, it's not just enough that they be intertwined, but they have to be intertwined enough to the point where it would be inequitable for the signatory to the arbitration clause to be so as to be stopped to deny the obligation to arbitrate with the non-signatory. And there are additional conditions. The courts then went on to say, yes, they have to be intertwined, and yes, that intertwinement has to be so extensive that it would make it inequitable not to have arbitration, but there also has to be a relationship between the parties. The issue of the non-signatories, if only in cases where the issues the non-signatory is seeking to resolve in arbitration are intertwined with the agreements that the estopped party has signed, and two, where there is also a relationship among the parties of a nature that justifies a conclusion that the party which agreed to arbitrate with another should be estopped from denying the obligation. but there are only limited types of relationships that the courts have allowed to create or to say that it would be inequitable for the signatory to deny, to be stopped to deny arbitration. And those relationships have been found only where the non-signatory is a parent company, a corporate successor, a guarantor, or a corporate affiliate of the signatory. And as between Ernst & Young and Scherzer International, there is no such relationship. I would argue that the issues are not intertwined with Exhibit 1. I would also argue that they're not so intertwined that it would be inequitable if DRI denied the arbitration. And third, the relationship that is required to create that kind of duty just doesn't exist in this case. So as a matter of law, the question should have been decided that no, the non-signatory here could not compel the signatory to arbitration. And then you have the issue that Ernst & Young, because now Scherzer is saying, well, really what's going on here is that once Ernst & Young is going to arbitrate its cases, they're an indispensable party here, and I can't have justice here until that arbitration is done. Well, to that I would say, to the argument that Ernst & Young is not an indispensable party, go right to the rule. The rule is very clear. Ohio Civil Rule 19A provides that a person who is subject to service of process shall be joined as a party in the action if, one, in his absence, complete relief cannot be accorded among those already parties, or two, he claims an interest relating to the subject of the action. The only one that would apply would be one, if it applied at all. But it's also long been the rule in Ohio that it is not necessary to join all tortfeasors to be named as defendants in a single lawsuit. A tortfeasor with the usual joint and several liability is merely a permissive party to an action against another with like liability. Those are U.S. court decisions. There's also decisions from around the country saying that Rule 19, as amended in 1966, was not meant to unsettle the well-established authority to the effect that joint tortfeasors or co-conspirators are not persons whose absence from a case will result in dismissal for non-joinder.
Are we applying the Ohio rules of civil procedure here or New York law?
Well, I was a little bit puzzled by that myself, Your Honor. I mean, it does say that New York law is to apply, but I think I recognize the old axiom, this is a matter of procedure, so I think it's my opinion that we're following Ohio laws of procedure here and substantive laws. But there would be some crossover that some New York procedural laws might be substantive in the application of this case. But no, my view would be that we are applying Ohio procedural rules here. And that being the case, Lane versus Huffman adopted the federal rules, and so they're very much the same. The interpretations given by the federal courts and around the country are very much the same. Ohio adopted this in 1975 officially. And in the case of Wilkerson versus Eaton Corporation, which is a 1994 case out of Cuyahoga County, the court had 3 alleged co-conspirators and would not dismiss the case for failure to join the 3 co-conspirators based on those principles. Now, that's the issue where I think that it's very clear, is that regardless of what you decide about Ernst & Young, Scherzer is not permitted to stay this action pending any arbitration. Full justice can be done between the parties here. If Scherzer believes that it requires more, then perhaps it can file a motion to join Ernst & Young as on the issues of contribution. And then we'll see what kind of agreement they have between themselves. But on that first issue,
Couldn't this result in absolutely diametrically opposed judgments? I mean, your theory is conspiracy against two people who conspired. Couldn't a jury against SI conclude that there was a conspiracy and the arbitrator conclude that there wasn't?
Well, you know, indeed, Your Honor, I'd have to concede that point because I participated in a case that was tried to the court and jury, and they came up with diametrically opposed results. And the fact of the matter is, they were both entitled to be enforced, right? So, yes, that happens, but that in and of itself does not disqualify this or require a finding that is an indispensable party. One would be fined by arbitration. Would it be exactly the same case? Procedures under the arbitration would be far different than the procedures under the triple case, under trial action. Yes, I could not disagree that that might happen. I don't think it would happen with my knowledge of the facts, but I could see where Drew tries the fact because I've seen it happen before. We all have seen it happen before. So yes, I would concede that. Now,
You're not disputing the findings of fact of the magistrate's decision?
no, not the least. I don't think, this is a legal issue here. And the legal issue here, Ernst & Young says Exhibit 1 is a contract. DRI says Exhibit 1 is not a contract. That's an issue of whether or not a contract has been properly formed. That is a legal decision. That is a legal decision that where the dispute at issue concerns contract formation, the dispute is generally for the courts to decide.
And you're just now reaching into that 5 minutes rebuttal. You may continue or reserve as you wish.
Well, I would say that you know, I would like to, I guess, proceed for a few more minutes. So the issue of formation is generally for the courts to decide, and that is also true under New York law. It is true in the Supreme Court under the Granite Rock versus International Board of Teamsters case. Ohio courts decide that the issue of contract formation is always an issue for the court to decide. The next issue would then be whether or not the cause falls within the arbitration clause. And as this court well knows, in Bachrach 1 and Bachrach 2, the court has consistently held that it is a judicial determination whether or not the subject of the lawsuit falls within the arbitration clause. This is also true in New York law. The appellant's brief has cited those cases. Now, I'd like to, on the issue of the court said that no, there is no consideration for this agreement. And the no consideration is that if you take a look at Exhibit 1 and you examine it, there are no obligations created in that document. Nobody has to buy anything. Nobody has to sell anything. There are no rights. There are no remedies. And more importantly, under Exhibit 1, it says Ernst & Young may at any time upon prior written notice to contractor terminate all or any portion of this agreement or the services with or without cause.
Exhibit 1, what's the date of that services agreement?
I want to say it's a 2009 agreement, Your Honor, but my memory is not so clear on that, so...
It wasn't the one that was to expire by its terms in December of 2012, correct?
No, that there was a subsequent agreement just for continued services that Ernst & Young continued to ask for after the termination date.
So regardless of what those prior agreements said, the agreement that terminated the relationship is one that was found by the magistrate to expire by its terms in December of 2012, correct?
Yes, whatever date that was, it did expire by its terms.
And the magistrate found that.
Yeah, right.
He found that was an agreement and that expired by its terms.
Well, he found that was the terms of Exhibit 1, and he did find that it was an agreement. And that's what I'm asking you to review, is whether or not Exhibit 1 is even an agreement. Does it have offer? Does it have...
Exhibit 1 isn't the one that was in effect at the time the relationship terminated.
Yes, that was the one, Your Honor. Yes, it was.
What's Exhibit 4? Exhibit 4 says they're going to provide continued services through December of 2012. Were they doing services under both agreements? Is that your contention?
No, Your Honor. One terminated and a temporary agreement was put in its place.
Well, an agreement, not temporary, but one that
Not,
was
you're not using the term
terminated.
agreement, another document. But I would say that regardless of that document, regardless of whether it's 1 or 4 or both 1 and 4, they have to be read in context with each other because 4 refers back to 1. The point is, altogether, those do not constitute any agreement. Nobody promises anything. Nobody accepts anything. The agreement can be terminated 15 seconds after it's signed with prior notice, but prior notice is defined as notice that takes effect upon sending the notice. So there is no consideration for the agreement. It is an agreement that either party can choose or not choose to perform. And that being the case, if that's not an agreement, then the arbitration clause within that document is also not. And that is a judicial determination. The magistrate's opinion would have, its legal effect is that any dispute between these parties, we now have to send to an arbitrator to determine whether or not they are arbitrable under the agreement or not, which is a position antithetical to what this court took in the Baccarat cases, and then decide whether or not they should go back to the arbitrator staying with the case. New York law and Ohio law stand for the proposition no. The issue of formation of contract, whether or not there's even a contract to enforce here, must always first be decided by the court. And in this particular case, the lower court ceded that responsibility to the arbitrator. It did so. Okay.
Regretfully need to inform you, you've utilized the entire amount of your 15-minute time. Thank you very
All right,
much.
thank you very much.
May it please the court. My name is Stanley Carson. I'm here today on behalf of Ernst LLP. I'd like to reserve 3 minutes for counsel representing Scherzer to deal with issues that deal specifically with Scherzer. The magistrate here held an evidentiary hearing and made findings of fact. The magistrate concluded that this matter needed to be arbitrated. The findings of fact are binding on this case and on the court because there was no effective review of the findings of fact. I think that enters most of the appeal, and I'd like to start with the threshold issue. The Supreme Court of Ohio in Belmont and the appellate court in Sasaki versus McKinnon, and those are Ohio cases. The Supreme Court decision is the law for this case. Held that where an agreement specifies that arbitrators are supposed to decide an issue, that's an issue for the arbitrators. There's no dispute that an agreement was signed, and there's no dispute that the magistrate held and found that that agreement had a clause which said all issues of enforceability and scope are for the arbitrators. And in fact, what that agreement also said, any issue concerning the extent to which a dispute is subject to arbitration is also for the arbitrators. My client has an arbitration agreement with the plaintiff. There's a conspiracy allegation against both defendants. My client does not want to be dragged into another case in court as a third-party defendant as has been proposed to this court. My client's interest is to have this thing resolved in one proceeding if it's going to be involved at all. That's precisely why it has an arbitration clause. So as the magistrate held, and I believe is correct, where a clause says something is for the arbitrators, it's for the arbitrators under Belmont, and no other issue has to be resolved because everything is for the arbitrators, as the magistrate held. But if that were not the case, the result would be no different. Initially, the only challenge, again, as the magistrate found to the clause, was to the entire agreement. When that's the case, under a governing Supreme Court precedent, that also is a matter for the arbitrators. So for both those reasons, this dispute is for the arbitrators. DRI can present its arguments before the arbitration panel as it agreed it would do. Talking about the merits for a second, if I could. Probably a little more than a second, I apologize. So the first argument is the contract is not a contract. The magistrate found differently. I believe I believe actually is a finding of fact. But the magistrate was right for so many reasons that let me just give you a few of them. First of all, the agreement did have other conditions. It had a condition of confidentiality. It actually said that when a term expired, and the contract said it couldn't be modified, which is another restriction. When the term was ended, whether voluntarily or pursuant to a notice, the services that had been provided had to be concluded and paid for. That is an obligation separate and apart from the arbitration clause, and both under Ohio law and under New York law, it doesn't have to be specific consideration for the arbitration clause, so long as it's consideration for the agreement as a whole. In fact, the case that it's cited in the briefs is a Sixth Circuit case that cites an Ohio appellate court decision called the Fazio versus Lehman Brothers case, which is in the briefs. But as Ohio has also held in the Landmark 21 case, and it's true under New York law as well, when there's any restriction on an ability of a party to do an act, even with this termination of a term of an agreement, and that's all it was, a termination of the term, that is sufficient consideration so that there is still a contract, as the magistrate judge also found. Excuse me, as the magistrate also found. So under Landmark 21, there's a contract. There's other law that says where the parties perform to the end of the agreement, which is what the magistrate found here as well. Under New York law, there's a 2012 Court of Appeals decision, which is the highest court in the state. And it's a district court opinion within the last 2 or 3 years saying that's enough to also have consideration. So there are at least 5 or 6 reasons why under New York law and under Ohio law, because there's no difference on this point, the contract is indeed fully enforceable as the magistrate found. So that takes us really to, again, back to Scherzer, just a few words on that. The case that we relied upon before the magistrate, and the briefing before the magistrate went a little different. We relied upon a case from Ohio, a federal court case called Leibke. We also had the Kentucky case, which followed the same rule. The rule in the Sixth Circuit, though admittedly it's a uniform rule in the district courts, the Court of Appeals, the Sixth Circuit, hasn't dealt the issue, is that where there's a conspiracy allegation against 2 parties, and one of them is a party to an arbitration clause, it is certainly the case that that party can bring this dispute into arbitration. And that's the cases that the magistrate followed. There's no Sixth Circuit law contrary. I will tell the court there's Sixth Circuit district court opinion subsequent, which confirmed that's the rule among district courts. So that is the test that is used in the Sixth Circuit. That's what was argued to the magistrate, whether that was proper Sixth Circuit law. There was nothing argued about Second Circuit law at all on that point. And it makes perfectly good sense when you have when my client is being sued as a conspiracy, where the allegation is that we terminated the agreement, contrary to what the magistrate found, but that we agreed to terminate the agreement as part of a conspiracy that directly relates to the contract, and it's exactly why my client wants that entire dispute in arbitration, because otherwise, as we've heard today, it runs the risk of either one, having discovery against it in the second case, which was not the intent of the clause, or worse yet, being brought in on a third-party complaint. That's not what my client thought they were getting when he signed an arbitration agreement, and this is a broad arbitration agreement under Ohio law. Anything that arises, as the magistrate found, from the relationship is subject to arbitration. That's what the magistrate found. The magistrate was correct, and therefore the dispute, I believe, is subject to arbitration.
Did the magistrate also find that the issue of whether or not it was arbitrable was for the arbitrator to decide?
Yes, the arbitrator first held that it was, but then held that if I'm wrong or whatever you want to put it, but he went on to say, but if that were not correct, then it's still enforceable for all these other reasons. So I guess what I would say is it's sort of an alternative holding, but we did argue, and we do think, that it's for the arbitrators and the magistrate, and then adopted by the judge, held precisely that, Your Honor.
And do you read the entries to also make that finding as it relates to Scherzer, meaning, I understand you don't represent that in the hearing, but meaning that it's for the arbitrator to decide whether or not the claims against SI are arbitrable claims, are to be arbitrated?
That's how I read it, Your Honor.
Okay.
And that's how we argued it, for sure, because my client did not want to be in 2 forums on the same dispute. That would be contrary to the intent and spirit of the clause.
Why would you be in 2 forums?
Because, as we heard, if we were in arbitration, but Scherzer was in court of common pleas, for example, then there'd be two cases, and we'd be subject to discovery in both cases, as permitted by the clause in arbitration, as permitted by the court rules in the court proceeding. And then what I also heard today from counsel for the DRI was, well, maybe Scherzer can implead my client in the court of common pleas case. And if that's true, then I'm clearly in both cases, and that is not the intent of the clause. It's a broad clause designed to say all the disputes that we're involved with have to be in arbitration.
Well, I think, and I could be incorrect, but I think I heard him just say that your client is not an indispensable party to, so are you talking of being interpleaded by SI?
Yes, and that's precisely what counsel suggested could be done. And that's precisely what my client doesn't want to happen. But even if it did happen, we'd have all these costs from, I'm sure it'd be subject to discovery, we'd be witnesses, there'd be a risk of inconsistent adjudications. It really would not make sense. Would not make sense, at least from a judicial economy perspective and cost and burden on the parties, to have the case proceeding in two different forums at the same time when the discovery may be the same, when the clause talks about the extent of the extent of whether something is subject to the clause is for the arbitrators.
And you may have said this, but I didn't catch it. Do you agree, Judge Cannon asked whose rules apply, whether it's New York or Ohio, and counsel for the appellant indicated that Ohio rules would apply. Do you have a position on that?
1 second, if I could, apologies. Well, what I think, though I will confess that I thought it through right here, is that I think that the Ohio rules of procedure would apply to the procedural matter wasn't an indispensable part. That New York substantive law and the making of contracts applies to that issue, as the FAA makes clear. It goes back to the FAA. What the FAA says is, for matters of contract, that the laws that uniformly apply to the rules of contract apply to matters under the FAA. So here there's an FAA agreement, so the FAA applies, but then if it's a matter of whether the contract is enforceable as a pure contract matter under the FAA, you look to state law, and therefore the provision in the agreement which says you look to state law would mean you look to state law on that. But I don't think that would mean that you look to state law on a matter of indispensable party under Rule 19 or the analog.
Thank you.
I assume that was the work time I had. So.
Yeah, pretty much. It's about 3.5 minutes left.
Okay,
Thank you.
I promised.
May it please the court, I'm Donald Scherzer with the law firm of Russell Andrews, and I represent Scherzer International. I have a very short period, so I'll try to be as concise as I can. The issue I'll be commenting on is whether the arguments made by DRI in its reply brief, which were not raised in the lower court or raised in its opening appellate brief, are even properly before this panel. I would argue that they are not. Specifically, the panel should disregard DRI's arguments that the determination of this question be decided under New York law, as it argued in its reply brief, or whether it should be decided under the Federal Arbitration Act, as DRI argued in the trial court and in its opening brief. So the new argument raised late in the game should not be considered by the court. But if the court decides to consider that argument, please note that the cases were not properly cited by DRI, and in fact, they support the proposition that this case should be arbitrated against SI as well as DRI. In both its trial brief and the appellate brief, DRI repeatedly cited to and consistently relied on the rule of the Sixth Circuit, and where the non-signatory compelled arbitration under the FAA. In arguing against an order compelling DRI to arbitrate its claims. However, the trial court explicitly relied upon the same precedent when it granted appellee's motion to compel arbitration. The Ohio Supreme Court has clearly established that issues not presented for consideration below will not be considered on appeal. Additionally, a number of Ohio appellate courts have consistently held that new arguments raised for the first time on appeal are waived for purposes of that appeal. Because DRI relied on the rule for courts sitting in the Circuit under the Federal Arbitration Act in the trial court in its open briefs, this court cannot and should not consider whether the argument raised by DRI to apply New York State law is applicable here. DRI cited to 3 decisions by New York federal courts in its arguments against SI's right to arbitrate this matter. But that does not implicate the failure of its of raising the New York State law in its opening briefing before the trial court, because those decisions interpret federal law, not state law. They rely strictly upon federal arbitration law. Importantly,
Counsel, I need to inform you that you've reached the remainder end of your time for today. Thank you. Thank you all for your presentations this morning. The court will take the matter into advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you.